As we have seen, the Arizona Department of Real Estate, ADRE, maintains rigorous oversight of timeshare developments to ensure fairness, transparency, and consumer protection. Once a timeshare developer has registered a notice of intent to sell, obtained a public report, and remains in compliance with amendment and disclosure requirements, the next foundational step is the creation of the legal instruments that define the rights, obligations, and governance of the timeshare plan. These instruments, most notably the Declaration of Timeshare Plan, are the backbone of the legal relationship between the developer, the management entity, and the purchasers. ARS Section 322197.02 Notice of Intent to Sell. Application for Timeshare Plan Public Report. This statute requires a developer to register a notice of intent to sell and file an application for a public report that must include a comprehensive statement of the timeshare plan and related information as part of the official declaration of the plan. They establish the operational structure of the timeshare and are enforceable under Arizona Revised Statutes, Section 322197. The Arizona Department of Real Estate, ADRE, enforces compliance with the timeshare declaration as part of the approved public report. If a developer violates or deviates from the declaration, for example, by changing use rights, fees, or accommodations without approval, ADRE may impose administrative penalties, issue cease and desist orders, suspend or revoke approvals, and require corrective action, including amended public reports. The declaration, sometimes referred to as the Timeshare Declaration, or Declaration of Covenants, Conditions, and Restrictions, must contain specific provisions that clearly describe how the timeshare operates, how ownership or use rights are allocated, and how maintenance, governance, and financial obligations will be managed. These provisions serve as the governing framework for the project and are recorded with the county recorder in which the property is located, ensuring public notice and legal enforceability. Under ARS Section 32-2197.06, the following general provisions are required to be included in the declaration or other governing documents of a timeshare plan. First, the declaration must fully identify the accommodations and common elements included in the timeshare plan. This includes a legal description of the property, the number of units, and a statement of which portions are subject to shared ownership or use. For example, a resort might specify that all owners share access to common facilities such as the pool, clubhouse, and parking area, while owning a fractional interest in their assigned accommodation unit. Second, it must clearly state the type of ownership or use interest being conveyed, whether it is a deeded interest, fee simple, a leasehold interest, or a right-to-use contract per ARS Section 32-2197.02b14. This distinction has significant legal implications for the purchaser. For instance, in a deeded plan, the purchaser acquires a tangible ownership interest in the property recorded in county records, whereas in a right-to-use plan, the purchaser merely acquires contractual usage rights for a specified term. Third, the declaration must define the duration and configuration of the timeshare periods. Under ARS Section 32-2197.08, it must specify the frequency and length of use intervals, for example, 1 week per year, as well as whether the weeks are fixed, same calendar week each year, or floating, based on a reservation system. This helps ensure that each purchaser understands exactly what they are acquiring. Fourth, the declaration must outline the procedures for managing and maintaining the property, including how the association or managing entity will operate. It must describe voting rights, governance procedures, and financial management systems, including how assessments or maintenance fees are calculated, billed, and collected. These provisions are essential to prevent mismanagement and to maintain the quality and value of the property. Fifth, The declaration must include the rights and obligations of both developers and purchasers. This includes maintenance responsibilities, rights of inspection, restrictions on usage, transferability of interests, and the process for dispute resolution. For example, a purchaser may be prohibited from renting out their timeshare to third parties without approval, or the developer may be obligated to maintain all shared amenities in good working condition. Sixth, the declaration must specify the procedure for amendments. Timeshare plans are dynamic and may evolve with time, so the declaration must set forth how amendments are adopted, whether by vote of the association, consent of a majority of owners, or approval by ADRE. This prevents unilateral changes that could unfairly affect existing owners. Seventh, the declaration must address the rights of first refusal or resale restrictions, if any. These clauses determine whether the developer or association has the right to purchase a timeshare interest before it is sold to an outside party. Such provisions help control ownership structure and maintain stability within the timeshare community. Additionally, the declaration must include insurance and casualty provisions. The document must outline the types of insurance required, such as liability coverage and property insurance, and explain how proceeds are handled in the event of damage or loss. It must also explain what happens if the property becomes uninhabitable due to destruction, whether the plan dissolves, is rebuilt, or compensates owners accordingly. Another key element is the procedure for termination of the timeshare plan. The declaration must clearly define the method and majority vote required to terminate the plan, distribute proceeds, and settle ownership rights. For example, if a timeshare resort reaches the end of its useful life, or all owners vote to dissolve the plan, the document must specify how sales proceeds are divided among owners. A practical example can be seen in the Sedona Summit Vacation Ownership Declaration, where the recorded document outlines the description of accommodations, defines the management company's role, provides voting rights for each ownership week, and sets out detailed maintenance fee formulas. This level of specificity protects both the owners and the management entity from misunderstandings or misrepresentation. Failure to include required provisions in the declaration can have serious legal consequences. Under ARS Section 32-2197.10, ADRE may suspend or revoke a developer's authorization to sell timeshares until deficiencies are corrected. In addition, purchasers may have grounds for rescission or civil action if the omission materially affects their ownership rights. The State ex rel Arbeit, ADREV, Canyon View Resorts, LLC, 2016, case demonstrated that omissions in a recorded declaration, such as failing to define maintenance obligations or ownership allocations, constituted a violation of the Timeshare Act, resulting in penalties and mandatory corrective action. Review summary. The declaration of a timeshare plan serves as the foundational document that governs the entire operation, ownership, and management of a timeshare property. Under ARS Section 32-2197.10, it must include detailed provisions addressing property description, ownership type, use periods, management structure, financial obligations, amendment procedures, insurance requirements, and termination conditions. These elements ensure legal clarity, protect purchaser rights, and maintain the integrity of the timeshare project. Failure to comply with these statutory requirements can lead to administrative penalties, rescission rights for purchasers, and reputational damage to the developer. Discussion prompts. Why is it important for the declaration to specify the ownership structure, deeded versus right to use? Answer. It defines the legal nature of the purchaser's rights and determines how those rights can be transferred, inherited, or terminated. What risks arise if a declaration fails to describe maintenance and management responsibilities? Answer. Ambiguity could lead to disputes between owners and developers over who is responsible for upkeep and associated costs. Why must insurance provisions and termination procedures be included in a timeshare declaration? Answer: they ensure that owners understand how property losses or dissolution will be handled, preventing confusion and financial loss. Closing remarks. The declaration is the heart of every timeshare plan. It translates the developer's promises into legally enforceable obligations and provides the framework that guides the community's daily operations. By requiring detailed and transparent provisions, Arizona law ensures that every timeshare is governed with fairness, accountability, and predictability. For real estate professionals, understanding the components of the declaration is vital not only for compliance, but for helping clients make informed decisions and protecting the integrity of the real estate industry as a whole.